Good afternoon, good afternoon, good afternoon, and welcome to the monthly HSB Employment Webinar. My name is Joseph Dickey. This is my law partner, Garrett, Steck. You could be anywhere in the world eating lunch or doing something else, but you decided to be here with us. So thank you very much. We're here to give you an hour of continuing education credit just to update you on some employment things. Today is employment-based immigration and employer compliance update, which means we're going to talk about the administration's executive orders regarding DEI, some of the DOGE, and how it impacts employers, higher education institutions, school districts, and others. So glad you're here. Glad you're here. Before I turn it over to Garrett to get into the immigration, because he's the immigration guru, I want to just remind you we are a full-service corporate law firm representing employers and other entities. We have 115 plus attorneys and 5 offices across North and South Carolina, Raleigh, Greenville, Columbia, Florence, and Charleston. And so if we could ever assist you in any legal capacity, please let us know. And with that, Garrett, Steck, go ahead and let's drop some knowledge and try to assist our clients and people. Thank y'all.
All right, thank you. And again, good afternoon. We're going to talk briefly today, sort of provide an immigration update. Next slide, please. When we're going to talk and just very briefly hit some of these items, you may be well aware of them. Real ID, I-9 employment eligibility, just current forms and questions, passport entry stamps and admission requirements for immigration, and more importantly, fee increases and form changes, the H-1B modernization rule, and the FY 2026 lottery registration for H-1B visas that starts next month, and recent developments, and that should just really be political developments since January 20th. So with that, we will jump right in. Next slide, please. Next slide. So Real ID, I date myself, but one of the things I did almost 20 years ago was I was invited to participate on the South Carolina DMV task force for the implementation of Real ID. That was a long time ago. And finally, after many delays and iterations and changes, Real ID is becoming official. Implementation date is May 7th, 2025. Again, it could be subject to pushback, but right now that looks like we're finally moving forward with that implementation date. Obviously, this was passed by Congress 20 years ago. It establishes security standards for state-issued driver's license and identification cards that will be used by the holder to basically go through checkpoints at domestic airports, entering any federal buildings, military installations, nuclear power plants. Basically, it's just updated credentials, and by updated, it generally is trying to minimize fraud. And by going to SCDMV, next page, the government will issue you a driver's license with the gold star in the right corner. And that just means you're compliant. And really, to become compliant, if I remember when I renewed my driver's license a few years ago, it was just some additional information regarding me personally. I think I'd provided a passport and some utility bills when I renewed and extended my license. So in the back of your mind, if you haven't, or you are thinking about renewing your license, remember the additional Real ID document requirements. And if you travel in the airport, if you don't have this, you will need a US passport. So just saying that we're right around the corner, March, April, May, about 68 days, 64 days out before the implementation date. So just FYI. Next slide. So Form I-9s, we're going to just talk a little bit about Form I-9s. Again, everybody on the call, if you're involved with HR, you understand and are well aware of the I-9 requirements, including for South Carolina E-Verify. But just to remind you, because yet again, I still receive calls from employers in South Carolina, basically last week, where people were still not entirely sure of their I-9 requirements and had no idea about E-Verify. So I-9 was basically, it's a federal law requiring completion of the I-9 form that came out of a 1986 federal legislation that basically required the use of I-9s. And then still to this day, there's still a few people when we conduct audits that still do not have an I-9 because they were hired before 1986. But otherwise, everybody needs an I-9 form. Probably in this political climate, I would recommend that everyone make sure that they have their documents up to date. We'll talk a little bit more about that at the end of this presentation, but it is time basically. This is a good time to review your I-9 compliance, your I-9 forms, your retention policies for compliance, because the government is going to more than likely, from what we're hearing, increase scrutiny, audits, and such. So we'll talk about that in a little bit, but definitely a good time just for everybody to make sure, because we did have a few clients that in the past printed out a number of I-9 forms online, had the manager sign all of them, and then put them in the personnel file for new hires. And every time someone was hired, and this was a restaurant, so it was very frequent, they pulled out the pre-signed I-9 form and had the employee complete that. So of course the I-9 form changes, and they were using outdated I-9 forms for many years. So last year the I-9 form changed. Basically it went from 2 pages back to 1 page. It's a 8/1/2023 form with an expiration date of July 26 or May 27. You can find those dates, the addition date at the lower left corner, and the expiration date it's at the top right corner. So next slide.
Garrett, we got some questions I wanted to read to you so you could try to answer.
Yes.
First one is, can new hires still use their regular driver's license for their I-9 form as a list B, or will they need the real ID?
No, but regular license or identification card is fine, as long as it's not expired.
Then another one is, what if there's not, I think you might have covered it, but what if there's not I-9 for the employees that have been with the company over 20 years? What do we do?
If they were pre-hired, if they were hired before November of 86, they don't require an I-9 form. If they were hired after that date and there is not a form, you can complete a form. You would use the original date of hire, but you would use current signatures and current documents. Again, just to have that, because if the government ever audits you, they're going to look at your current payroll and prior payroll and just match up an I-9 with every employee. So you could make a notation on that form or on a note attached to that form. As part of an audit, this person had been with the company for 20 something odd years, and they were apparently either lost or not completed. And then here's an updated I-9 form. So that's, you can do that. I don't recommend that you go and e-verify someone in that case, but you can and should have a paper document, or if you electronically maintain your records, an electronic I-9. So as you can see on this current slide, this is the 1-page form, single page, new, and then in addition on the older forms or prior forms, they had the re-verification, rehire, and interpreter, translator, and such on the forms. They've moved that to new supplements. So most importantly, the supplements for re-verification, for if you employ any foreign workers, the re-verification form becomes much more of a critical piece, because employment authorization is generally only temporary until that individual receives a green card or becomes a naturalized U.S. citizen. So again, the 1-page form, clean, easy to complete. You can actually download it. You can fill it out online, and basically it eliminates a lot of the mistakes that were made in the old I-9 forms, where people had the wrong box and filled out the wrong information and did a lot of errors that, really they're administrative penalties. They result in administrative penalties, but in the end of the day, they still have the information, but the government would penalize you if it was in the wrong box, for example. A lot of times people signed above the line or below the line, not where next to the signature block. So this new form sort of eliminates a lot of that. For all the audits we're looking at, ever since these newer forms have come out, the incident of compliant or incident of errors has gone down and compliance has gone way up. So next slide. This is just the supplement page on re-verification and rehiring. So that's just an example. So next slide. Remote form document inspection. There's a box in section 2 where you can select if you do that. If you do it, you need to be consistent in doing so. Again, we'll get into a little more reasons why at the end of the presentation, but that's just to make sure that everybody on the call is aware of the correct and current form to be using. Again, E-Verify is a South Carolina requirement under SCIRA since 2000, well, officially prior to, but since 2012, all South Carolina employers are required to register and use E-Verify. And then on all I-9 forms, when you run your E-Verify case, either print out the case verification or confirmation and keep that with the I-9. Some individuals decide they just want to put out the case confirmation number on the I-9 form itself. Either is fine. So next page, you can skip over that. That's just highlighted in yellow is the box to check for remote inspection and sort of the flow chart for remote inspection. So that's pretty standard. Everybody's aware of that. Next slide, passport entry stamps. So this is critical if you're hiring a foreign worker, obviously. Long ago, if anyone has traveled internationally, you always remember coming back into the US, flight attendants would pass out pieces of paper. If you were a US citizen, it would be the declaration pages. If you were foreign, it would be an I-94 arrival record that you would pre-complete. And when you went through customs, immigration would stamp that I-94, stamp your passport, and then that document would be evidence of the individual status. Status is also indicative of employment authorization in many cases. And most importantly, the number on that form is the number that you would use to put for to complete a temporary worker's I-9 form. So those I-94s were critical. Well, the government has basically started moving away from the physical stamping. Well, they've moved away from the physical paper. They're moving away from the physical stamping. And it's now when you're admitted, your passport is scanned into the system and your immigration record appears online, where you can print out the form that basically says, it's the same information that used to be on the stamp, where you entered, what port of entry, the date you entered, your status that you entered in, plus when does that status expire? And then the I-94 number, all of which was, like I said, used for immigration status, whether the individual was completing the onboarding process, was applying for a driver's license, possibly opening or applying for a social security card. That is the critical information. So that information that used to be in the passport and used to be on a separate piece of paper is now online, accessible by anyone, as long as you have the passport data information. So next page, please. So next page, one more. So this is a copy of the I-94 that's available online. And again, admission, the first, as you go down, the first admission or I-94 record number, that's the critical number. Arrival date, class of admission, E2 in this case. Most importantly, if you'll see in yellow, admit until date. So the individual entered in E2 status, which is a visa classification. And that individual was admitted into the United States for 2 years, approximately, until, in this case, November 25th, 2026. That is the critical date, not only for the individual to be aware of, because that's the date their status expires, that's also the date, for the most part, that would be on any I-9 form with an expiration date. So you have to, obviously that puts us back into the re-verification. Because if this individual has an E2 visa that's valid for 5 years, was initially admitted for 2, you would then, when this person would then travel and basically obtain a new entry, and for additional 2 years, you would have to then take that information and update your I-9 form. And then, of course, the name, birthday, document number, which is the passport number, and the country of citizenship. So that's the information that the individual needs and the employer to complete the onboarding process. So next slide. So big changes last year across the board were fee increases and form changes. So April 1st of 2024, new fees for immigration benefits. And which was very interesting is that coincided with the H-1B lottery result and the 85,000 applications for H-1B status that were filed starting April 1st. Interestingly enough, when prices doubled or tripled. The new fees are a result of comprehensive fee review. Government agencies' fee structure really hasn't been that updated since 2016. It's funded sort of like the post office. USCIS is funded by the application fees. And as immigration grows, there's increased demand for these fees. So the fees have gone up. Unfortunately, for those on the call that deal with immigration in the employment world, a lot of the fees increased on the employment side immigration, not the family side immigration. This new fee schedule is so bad that the USCIS basically amended their G1055 fee schedule, which used to be 2 pages and is now 56 pages in length. They didn't add any more forms. It's just that every form now has different fee structure associated with it, depending on the benefit you're claiming. So like, again, what used to be 2 pages is now 56 pages. Again, I kind of equate that to the I-9 not instructions, but the online M274 guidance for completing the 1-page I-94. Excuse me, the one page I-9. It's like a 70-page document. This is insane. 56 pages on how to figure out how much to pay, and then there's another document that's almost as long that tells you where to file, again, specific to the benefit that you're requesting. And then with this new fee structure, USCIS revised most of their forms. So you have to make sure, not only now, do you have the correct form? Do you have the correct filing fee? And do you know where you're sending the application? In the government's defense, they are trying to push a lot of this to electronic filing. It is a terrible system for employers. It really was developed for family-based, where someone's doing it for themselves. But when you add an attorney and an employer to the mix, it becomes rather complex and cumbersome. Next slide. This is just an example of the fee increases that we saw. The base petition, say for an H-1B visa, went from $460 to $780. L petitions went from $460 to $1,385, over 200% increase. And you can see it across the board, lots of increases. And then this year, the H-1B registration fee went from $10 to $215. So lots of increases. So next slide, please. This is just a sample. So when I say 2026 H-1B filing fees for an employer with more than 25 employees, first of all, yes, it is 2026, not 2025, because we file 6 months prior to October 1, which is the start of the government's fiscal year for 2026. So the H-1B lottery held in March of 2025 is for the 2026 fiscal year allocation. So if the individual employer wants to sponsor an H-1B worker and they have more than 25 employees, and you elect to pay premium processing, which can be paid by the employee, it's $6,185 in fees payable to the federal government. And that excludes legal fees and costs, translation, educational equivalency determinations, legal fees, FedEx charges, etc. So H-1Bs are a costly endeavor. So as we continue to move through this quickly, the other big change that occurred just recently regards H-1B, the H-1B program and H-1B eligibility, and it's called the H-1B modernization rule. So historically, H-1B visas have always been available to foreign nationals in a specialty occupation. And it's always been the theoretical and practical application of highly specialized knowledge, which requires at least a bachelor's degree in the specialty. I.e., if you were an accountant, the government really wanted to see an accounting degree. If you were an engineer, they wanted to see an engineering degree. Computer science degree. But over the years, there's been an explosion of different degree options. And there have been a lot of people trying to get into positions with other degrees. And this is becoming a problem with the more business related studies or degrees. Management science typically is could be an MBA. And an MBA without any specialization is not H-1B eligible, but yet these students are basically getting the STEM, this degree is treated as a STEM degree, and they think that they're automatically eligible for H-1B status, and they may not. And then this H-1B modernization rule, which basically just took effect, says they're redefining specialty occupation to say that now there has to be a logical connection between the degree and the duties of the position. For example, this is one that we are facing. We have a position with one of our clients for a data analyst. The individual has a master's degree in data analytics. The position requires someone with a degree in data analytics, statistics, mathematics, and the government came back and is challenging whether this is a legitimate H-1B application, because we now have to explain how all of the potential majors and experiential requirements meet the independently meet the H-1B regulations. Again, I think data analytics and statistics and mathematical concepts all sort of tie together. But again, it's just part of this, trying to streamline and make H-1B processing very specific. And we basically say, STEM degrees, science, technology, engineering, and mathematics by far. As part of this modernization rule, we're also looking at making third-party placement more difficult. This really pops up in the IT area, where you may have a company that hires or uses an IT consulting firm that provides IT talent. And this is distinguished from bringing in a company to update your network, or bringing in a company to reprogram your database or do something. That's a project. A lot of times these companies basically just are staffing agencies for skilled IT professionals. So now the individual would be working for XYZ company, but say, for example, AT&T would want these individuals placed on their facility. So it makes that a little bit more difficult. As part of the fee structure that I referenced earlier, site visits. There's a $500 fee that the government is utilizing now for site visits. And this doesn't apply just to H-1B, it applies to a number of different immigration classifications, where the USCIS can actually show up unannounced at your site and want to talk to somebody about your foreign nationals or the petition that the employer filed. We had someone call up, and believe it or not, he called me up because he couldn't get through the security gate. My information was on the immigration petition. And he was like, okay, so tell me about this petition. And I told him, and he said, okay, well, this is a very large manufacturing facility. I can clearly see that, the name on it, the address matches. I don't need to go inside, but I just wanted to verify that this was actually a legitimate company and a legitimate petition. And then the last thing that was changed of significance was cap gap extension. A lot of graduates graduate in April, May timeframe, and again, apply for H-1B status. And while they're applying for H-1B status, their employment authorization via OPT expires. And as long as an employer registered that employee in the lottery, was selected, and then filed an application or petition for H-1B status during the validity period of that student's employment authorization, that student could continue working. Even if the EAD expired in July, for example, could keep working until October 1st, the start of the 2026 H-1B fiscal year. Well, that's now been extended to April 1st, or March 31st. You can now, if you have an OPT employer or OPT employee, as long as the H-1B petition is filed before the EAD expires, but there might be a problem with the petition, or, as I'll mention in a minute, it might be a delayed petition because of a secondary lottery selection. You can, that individual can continue working even on an expired EAD up until the end of March of the following year. Prevailing wages change every July. The Department of Labor revises the occupational classifications and wage structure every July. We are seeing substantial increases across the board in a lot of categories. Normally it's been a 1 or 2% increase annually going forward. We're seeing 10% plus increases, if not more. 3-year H-1B renewals that we last looked at in 2022, wages are going up in certain occupations $20,000, $30,000, $40,000, which is significant because H-1Bs require payment that meets or exceeds prevailing wage. Last point that I'll mention here, because I know I'm running out of time, is work from home is becoming a very, ever since COVID, people don't always work from the office. For H-1Bs, the prevailing wage, which I just referenced, is in the location of employment. So if someone is moved and they're no longer, working, they're working from home, we may need to look at prevailing wage information for a whole nother state, another county or state for that matter. So we also, that's very, very critical going forward. So next slide.
Yeah, you got two questions if I
Yes.
can put them out there for you. First one came in, if you hire someone that is on a STEM OPT and they don't need immediate sponsorship once the OPT time frame is up, is the employer obligated to keep the employee?
No, two things on that. OPT is the optional practical training, which a student, an international student, can apply for when they graduate. And all students are eligible for 1 year of OPT. STEM graduates can extend that 1 year OPT for an additional 2 years of OPT. There's no obligation that you have to employ them for the full time. It's an at-will type of relationship. If that position is terminated, the student goes back to their university, updates their CVIS record, tries to find a new employer. Someone who is in OPT and you would want to sponsor them for an H-1B, because of the lottery, which we're going to talk about right now in this slide. Last year there were approximately 500,000 registrants for 85,000 H-1B visas. The year prior, almost 800,000 for 85,000. So the selection rate is very poor. So we do not recommend that you wait until like the last year of eligibility to try to get H-1B sponsorship, because more than likely you will not succeed. So to register for the lottery, the USCIS employer account must be created online, basic information about the employer and the employee, along with payment of the registration fee. That puts you in the lottery. The lottery is open on March 7th through March 24th, and then the USCIS conducts the lottery by the end of the month. So next slide. So that's just kind of what I just summarized. Between now and March 7th, create your registration accounts. Lottery opens, lottery closes. What I want to make just note of on this slide is September 1st. In the last few years, there's been a secondary lottery. And that has been, that's been odd, but it's been beneficial. And the secondary lottery is that the government says, okay, there's 85,000 selections, but of those 85,000 that are selected in the 90-day window, maybe only 82,000 actually apply, or maybe so 82,000 apply and then 2,000 are denied or incomplete and can't be processed. So basically they have a small remainder lottery if there's any visas left over by the, they do it at the end of August and early September. So if you're not selected by the end of March, there's a very small chance you might be notified if there is a secondary lottery, end of August into September. And then again, we start date October 1. Employees do not have to necessarily leave the United States if they maintain status during the summer through the cap gap or another status. October 1st is just a re-verification on their I-9 form. It's just a piece of paper with a new I-94 card and employment authorization. They do not, a lot of employees try telling employers they must leave, they must go back and get their visa. That is not necessarily always the case. And in this political climate, we don't recommend that anyone travels if they don't need to, because there's been a lot of changes. So I have about a few minutes. We're going to go down to next slide. Recent developments. So this is always fun because it changes daily, and it's changed daily since January 20th under the new administration. So we have basically through executive orders, initiative, and policy changes, there are efforts to find, apprehend, and remove millions of unauthorized immigrants. At last estimate, there's 15 to 20 undocumented people in the United States. And that does not all mean Central and Latin American Hispanics. It could be anybody that came over here legally and has just overstayed. It could be students, it could be workers from anywhere. But there's approximately 15, 20 million people in this status, and that's probably underrepresented amount. So one of the executive orders, executive order 165, securing our borders, closed the southern border, expanded funding for increasing the construction of the wall, importantly terminated a lot of programs and benefits, including United for Ukraine, DACA's status is up in the air, deferred departure, TPS, asylum. A lot of these categories that offered employment authorization are either being stopped, terminated, or otherwise changed, which may impact some of your current personnel. Enforcement and removal actions. deployment of military, state, and local law enforcement to help ICE round up people who are undocumented as part of this removal operation. Note, South Carolina Attorney General has issued or authored a letter urging to all sheriff, all county and city law enforcement officials, urging partnerships with ICE to encourage them to basically try to find illegal aliens. Enforcement in protected areas, historically churches, schools have been sort of off limits. Now nothing's off limits per se. And maybe for employers, it would be public space, parking lots, common reception areas, not necessarily patient rooms or individual offices. And then just recently, there's been talk about using the Alien Enemies Act of 1798 for expedited removal of these individuals, because that allows the government to remove them as enemies of the state, so they do not have to go through the formal immigration court system for removal. So it'd be an expedited removal process. Yesterday, government announced they're going to create a registry for all undocumented all undocumented aliens, requiring them to self-report name, address, and fingerprints and photograph. I'm not sure how well that's going to go, because I would think with all the enforcement actions, they might just have people waiting in the parking lot. So we'll see how that goes. And then yesterday I was giving a presentation and I missed the announcement of the gold card. That is the $5 million, and you can buy a green card if you basically donate $5 million to the US government. The administration said that's going to be effective starting in 2 weeks. I don't know if that's going to be physically possible, but we will see. Next slide. And last slide, since I'm in Joseph's time now.
You're fine.
Why is this all important? Because the impact extends beyond the undocumented alien and could have significant implications in the workplace. So employers need to prepare and establish, we won't say practices and policies, but just more than likely be aware of this changed immigration enforcement in this new administration. And the government is going to increase their rates. That is the unannounced arrival of the government that shows up. Chicken processing farms come to mind, or processing facilities where the government shows up with like vans, guns, and all sorts of people, and basically just comes in every door to basically stop anybody from leaving or hiding, and then tries to identify them, round them up, and then those that they find illegal, they basically arrest and deport. And that can happen with no advance notification to the employer. Enforcement action, site visits. We talked about compliance fraud site visits earlier with visas, but there's also enforcement actions through ICE Homeland Security Investigation Unit, which is I-9 audits. They can show up and just ask for the information, personally hand you a subpoena for documents, or what we're seeing are subpoenas are coming in through FedEx, and you have 72 hours to comply. Regulatory changes, compliance challenges, making things difficult. So therefore, thus, we would like to see I-9 compliance. If you haven't audited recently, it might be a good time to do so. We're also looking at travel bans. One of the executive orders basically said the government has 60 days to evaluate security of different countries internationally, how their passport security process and programs operate. And if the US government finds that they are not secure and up to date, they can establish travel bans. Back in the original Trump administration, there were Muslim travel bans. We're still hearing talk of travel bans. Not only Muslim travel bans, we're talking potentially Chinese, and we've even heard other countries that have weaker passport controls. What does this mean if you deal with, in the immigration world, longer wait times, increased scrutiny and vetting, i.e. we talked about the H-1B now, and all that leads to higher costs. So be prepared for, I guess the best word is be prepared for change, because this area is changing. Some of you might not employ any foreign workers, and this may not be a huge issue. Others that do, this could be potentially a large issue, because it could result in the loss of your workforce. I have received at least a call per day since January 20th, primarily from small businesses, whether it's construction, landscaping, labor-intensive positions, and everybody's talking about, I've got such a wonderful employee, I've been paying that employee on a 1099. He's wonderful. She's wonderful. They're great church people. They've got great kids. Oh, they're just awesome. What can I do? And the basic answer is probably nothing. And you need to prepare that you may lose this individual, depending on how these raids go and enforcement actions and activities go. So it's out there. That's something to be aware of. If you sponsor any foreign workers on visas, you need to just be aware of potential longer processing times, which ultimately add in more expense. And then at the end of the day, record keeping is going to be of utmost importance. Documentation for I-9s, visa documentation, hiring, anything you do in this world, you probably need to keep good records. So with that, I apologize that I ran over, Joseph, but now I'll let you take over.
You're fine, but we got some questions that I think that you would be good at answering that. I don't think they want me to answer these questions. The first one I didn't get to earlier. A company works with a subcontractor or a labor providing company. If there is a contract in place between the two parties stating the subcontractor or labor provider is responsible for I-9 verification and other wage compliance, what liability does the client company still need to be on the lookout for?
Well, I'll say that is correct. As long as it is a contractual obligation with a labor provider. But what we've seen recently, and this was even in the Biden administration, is that the government is now looking into that to see why you're doing this. And there's been a lot of instances where some of these labor providers know that their entire workforce is not legal. And we had an example recently where we went back under our contract and said, okay, wait a minute. Our HR director got a call from a sheriff's office in Wisconsin regarding one of your employees. And they were saying it's identity theft because somebody with the same name in Wisconsin couldn't apply for state benefits because she had a job in South Carolina. So obviously that made us look at who this person was. Then we went back to the contract and we looked at, okay, and we said, okay, we want to see all your documentation to prove that you did this. Well, lo and behold, they had never done an I-9 form for any of their employees. So even though they were contractually obligated, they never complied. And then that we were brought into it. So liability, you limit your liability through the use of a third party and through a contract. But what you don't want, and this also happened in the Walmart case where Walmart was fined $42 million or $45 million for using a third party janitorial service. And Walmart management knew that the janitorial service was cheap for a reason because all their workers were getting paid in cash because they were illegal. So Walmart was fined $40-something million and the people involved were actually criminally liable. So, it can come back.
Lawyers included, I would assume.
Yeah, it can come back, but generally, if it is a legitimate third-party labor provider, whether it's, an IT consultant, IT placement firm or general firm, make sure it's in your contract, make sure you have the right, if needed, to review their documents. Because at the end of the day, if ICE shows up at your business, they're going to find these illegal workers at your business. So you're going to get dragged into something you didn't want, even if it's as simple as, well, we know that these aren't your workers, but hey, while we're here, we're going to do an I-9 audit of all your workers just to be sure. So something to keep in mind.
And the last question we got, and I've seen this in some instances in my practice, but if with the administration's new immigration kind of actions, ideas, orders, how will it affect, you got countries like Japan or companies that like Japanese companies or Korean companies, otherwise in Asia and Europe that have expats coming over, like the executives. How is that going to affect them in the April timeframe? Is it going to be a negative impact or something we need to be considering?
Immigration processing, for example, the government quietly changed the requirements for interview waivers for visas this last week. They came out and completely changed what was required for interview waivers and didn't make any public announcement. It just kind of came out through people applying for renewals, and it was like, well, wait a minute, now we're not eligible. For this category, it used to be if you had a visa that was ever issued, regardless of category, if it's been expired for 2 to 4 years, you could still come back and be eligible for the waiver. Now it's 1 year and it must be in the same category. We are seeing, despite the government's actions to try to, save money, firing federal workers or encouraging, the email to justify your position, whatever, some of these governmental entities are losing personnel. And embassies are not heavily staffed in the first place. So we're seeing now appointments are becoming harder to obtain. It's taking longer to get appointments. We're seeing increased scrutiny across the board. That doesn't mean if you're going to the consulate in Busan, Korea, you're going in Sao Paulo, Brazil, you're going to Tokyo, Japan. It doesn't matter. The best thing is the best candidates make the best cases. There's been a lot of attempted fraud in the world, especially with the TN visas, where people have been coming in as a professional and the government does investigations and find they're actually working production, and they're overstating qualifications. It's just making visa processing a little bit more complex. Maybe complex is the wrong word, maybe just longer processing, which can result in a little bit longer costs. What we're recommending is that you monitor status, plan for any renewals well in advance, and make sure that if anybody travels for visa renewals, that you have contingencies in place if the individual gets stuck in that country. We've had individual physicians that left for a vacation, thought they were going to quickly obtain a visa, and then got subject to administrative processing, of course, because he's from the Middle East and he was a young male. So he all of a sudden, a week and a half, 10-day vacation turned into a 6-week ordeal. And then obviously there's patients scheduled, surgery scheduled, could be in regular business meetings, other, sales meetings, production problems. Just need to prepare for that. So we don't think it's going to get any better anytime soon. Historically speaking, going back to 2016 forward, that's just what we're expecting.
All right, thanks, Garrett. And I'm going to take over from here. And I don't have much time, but it was very important that everybody hears the immigration-based topic with Garrett. There's a lot of things that what the administration is doing with immigration that's going to affect all facets of your business or your operation, your company, and it's going to affect you if you run a governmental entity or a school, district, college, because that's going to start affecting some of your other actions, and kind of rolls into something that Garrett said: best practices, best candidates, DEI, and all the other words that have come into place. So I'm not going to spend too much time. I'm just going to kind of talk about some of the things that have happened since January 20th, which is further rescission or rolling back of executive orders pertaining to DEI or affirmative action or anything that would be, I guess, trying to encompass the Title VII discriminatory or protected class provisions into federal contracting or federal government. The first and most impactful one so far would be the rescinding Executive Order 11246, which required government contractors with 50 or more employees to have a contract of 50,000 or more to maintain affirmative action programs. This has spurred this one executive order, which has been politely called the Ending Illegal Discrimination and Restoring a Merit-Based Opportunity, has led to a flurry of many other things, which I kind of will go through, which is the Attorney General, the new appointed Attorney General, U.S. Attorney General Pam Bondi, issuing a memo on February 5th saying that the government will start looking into strategies to enforce this new order from the Trump administration for any employer or federal agency that is kind of enacting DEI programs. It's also led to letters from certain states, 19 states, ours, South Carolina, being also included in that group of people seeking to enforce the executive orders, sending letters, threatening letters, basically asking for or demanding compliance from to private companies with the administration's orders on DEI. So that's kind of what has been transpiring. It's been a day-by-day change, day-by-day something new, almost like a new combo at a Burger King. And, Wednesday, oh, we got a new order. Thursday, we got a new order. Or there's been a new action. So similar to the immigration, this has been happening on this next slide. Just to be quick, they got another order that came out. It's saying that we're going to have two sexes in the United States. Even President Trump said that pretty expressly in his first speech since he came back home, so to speak. And this wants to kind of, I think the order says that the holding in the Bostock-Clayton County case, which, as you remember, has gender identity as a protected class under Title VII. He says that the court interpreted it wrong. So the administration is trying to get Congress. They want Congress to look into trying to create legislation that will overturn the Bostock Clayton County case from the Supreme Court, which would say gender identity is not protected class. We deal with male, female, so no pronouns, things of that nature. Also, since that time, I talked about the memo, but go next slide. You've had other things that kind of like what Garrett was saying, that's going to probably complicate things when you're dealing with the federal government and certain agencies, or otherwise make things a little chaotic. There's a demand to dismantle DEI programs within government agencies. You're not recognizing any minority or other group, for celebration like Black History Month. And Office of Personnel Management also backed up the order and saying terminate all DEI programs, policies, practices. This has broad-reaching effects that goes to colleges, universities, grants that colleges, school districts may receive. I think we've seen something in Charleston where they can't give out a scholarship or something anymore. STEM programs that aren't being funded. So this really affects a large swath of groups or entities. Next slide. This is just a short summary of the memo that the Attorney General Pam Bondi put out. I kind of already said it. The government's going to start looking into illegal DEI in the private sector, including criminal investigations of corporate DEI programs. And for your purposes of the presentation, I've kind of cut and pasted this letter into the slide, into the PowerPoint. So if you get it, you'll be able to read it and go forward. Next slide. Next slide. Next slide. And this right here is the Costco letter from the 19 attorney generals, 19 states, our wonderful state included. And I'm not going to shortcut. It's basically a threat saying, this is what the administration has said about DEI. It's illegal. We need to have race neutral policies. Let us know when you're going to comply and get rid of your DEI programs. I think it's a 30-day timeline they gave Costco. I haven't heard anything about it as far as anything that has happened with that yet, if there's going to be a response, but that has gone out. Some other places are getting those type of letters. So just something to be on the lookout for. Next slide. Next slide. All right, so let's talk about DEI. I think everybody knows DEI is just trying to put a framework for people to all be on the same level. I guess you would say, to be short, leveling, not lifting. And so we want everybody to have equal opportunity, whether it's Black, white, Hispanic, Asian, alien, veteran, disabled, what have you. But it's been now co-opted to say that, all right, if it's DEI, it's illegal. Now, when we're talking about illegal DEI, can there be illegal DEI? What is illegal DEI? Well, let's find out. Next slide. Yeah, so y'all haven't read it. That's because it's important. DEI. What is illegal DEI? Well, there's been an example of that, and it happened before this second Trump administration. If you go to the next slide, it was in the Duval versus Novant Health case. Now, this was a Fourth Circuit ruling in 2024, but this was a case that actually kind of started in 2019, and it got litigated on up. This was a reverse discrimination claim brought against Novant Health under Title VII by a white executive. As you can see on the slide, the jury, they got a jury verdict. The plaintiff, i.e. the executive Duval, got a jury verdict of $10 million in punitive damage and over $3 million in back and front pay. What the issue was that the Novant Health had instituted a DEI program. This DEI program was supposed to be in phases. You go next slide. And in that program, you're trying to get more, I guess, diversity in your executives or in your leadership, management and leadership at Novant Health. In doing these phases, I think even Duval was on the committee for a little while, but soon thereafter he was terminated after having a good record. There was no real reason given for his termination other than he was going in a different direction. But later he learned that they replaced him with two deputies, both women, one Black, one white, and I think one of the women had lower performance rating than him. Then he was full out replaced his position by another person, which I think was a Black woman. What you end up learning, you go next slide, is that Novant's plan was more, I guess, quota based. All right, are we going to have this many people in this position, this many Black people, this many Asian people, this many women, and that was deemed unlawful. And that's before these executive orders. So what we're saying is that illegal discrimination, or you want to say illegal DEI, so to speak, has already been on the books with Title VII. And it's with reverse discrimination. And so if you're looking at your DEI plan, you just need to make sure you're not having a quota-based plan. You don't have a metric plan based on numbers. You're leveling the field or having a level opportunity so everybody can have a chance to get a job or get promotions, get compensations. But if you're saying, all right, we got a new VP position, this has to go to an Asian person, or this has to go to Garrett because he's a veteran, then that probably will be deemed illegal if the administration follows through with the scrutiny and the investigations they say. Now, another interesting thing, and I'm kind of jumping all over the place, is what Garrett brought up is the Walmart case about the $42 million on the penalty. And they hired this third-party company. That gets into False Claims Act threats that the new administration is talking about. If you have a company or you are a subcontractor on a federal contract, and you're not complying with the executive orders, especially the one rescinding 11246, you could be deemed to have committed a False Claim Act violations. Now, the wording of the executive order kind of tries to bring out the elements of a false claim provision, saying that by administering the grant or having the contract, or you sign this being a subcontractor, you are showing that you know that this is a federal contract. You know what the executive order means. You know that DEI is deemed illegal by this administration. And you know that this is your knowledge and certifying that you're not engaging in illegal DEI is material to the government paying you, which goes towards the false claim elements of, making a false statement, knowingly making that false statement, inducing the government for payment, and that false statement being material, and then receiving the payment. Now, I don't think that that's going to be easy for administration to approve if they start moving forward with that, because you still have to prove that the DEI program or other actions that the company or the agency was doing was illegal under Title VII, because Title VII is still on the books. Last I checked, Garrett, I don't know about you, still there. Yeah. So I think you have to, it's going to be hard, but depending on how the executive order is interpreted by courts, this is something that we'll need to look at. So let's just go to the last slide, because we don't have much time. I think we all have heard about Doge. We all know that's Elon, the Teslas, the deferred resignation, the emails, and the responses to the email. They're trying to, cut back, clean, prevent government waste, all those things. We've heard about that. What you might not have heard about, and I'm glad you stopped there, Keely and Raven, is South Carolina, here in our state, across the street from me, they are trying to incorporate the executive orders into legislation. There's an anti-DEI bill that is, I think it made it past the House. I'm not sure where it has, if it's failed or if it's still being debated at the Senate. And then there's another bill that is also in the House that is being considered, that is saying no DEI in education. So this is our state trying to incorporate the administration's EO's executive orders into state law. So just be aware of that. We'll keep monitoring the progress of the bills and let everyone know. But the key phrase that Garrett has said in the beginning of the webinar, it's been said in the middle of the webinar, and it's about to be said again, is what do we do to be prepared or be prepared? This is a missed opportunity, Kelly. We should have had the Lion King soundtrack being played with Scar. Be prepared. What can we do to be prepared for all of these things? So let's talk about what you can do. We need to have a privileged audit of your DEI programs or any diversity initiatives you have. We can help you with that, or if you have attorneys, you can get help with that. But you need to make sure you're not having quotas, quantitative metrics when you're looking at it, and you're just looking at how you provide an opportunity to your employees or however your programs are going about. You need to conduct training with your managers and supervisors to kind of ensure that they know how to address certain things that might come up, whether that's opposition with DEI or whether that's people in favor of DEI, or even better yet, with the climate today, at least what I'm seeing in some of my clients is just dealing with the politics in general. Review your policies in your handbook. Make sure your managers, supervisors, HR directors, or whoever are able to address this. Some things that you can suggest are, have an open conversation on safe spaces, seminars where employees can get together and talk so you don't have the tension. However, you also need to have training on your whistleblower policies. If someone does want to complain about the DEI program, you need to understand how that procedure, how that investigation is going to work, looking into it, and how you're going to document. I think Garrett talked about documenting on the immigration side. You certainly need to do it on this side. Other things, any audit or investigatory procedures already on the book, other documentation of discipline or employment decisions, make sure you review those policies and make sure you don't have any, I guess, holes or unintentional holes that you might have in there, so that you can make sure when you do take a step to investigate something or make a decision, that you have all your ducks in a row. Because right now, I think you're seeing a lot of challenges. At least I'm seeing a lot of challenges to everything that's been coming up from some of my clients, and some of the things that were more casual and how they address verbal counselings or other things of employees have blown up, and they shouldn't have blown up. And so the more documentation you have, the more formal procedures and consistency would be helpful. Now, we're stopped on the slide about the preliminary injunction, and this applies to higher education entities. This was a lawsuit that was filed by National Association of Diversity Officers, I think City of Baltimore, and some other plaintiffs against the Trump administration to prevent or enjoin the enforcement of some of the DEI executive orders. On Friday, this injunction was granted in part, and basically prevents the rescinding of grants money to the higher educational entities and any investigations or prosecution of false claims against those entities until a later date. Now, this injunction probably is going to get appealed by the Trump administration, but for right now, this injunction is in place, and at least for higher education entities, those portions of the executive orders are not going to be enforced. And we have the order kind of cut and pasted into the slides for you to read, but you can also find it anywhere off the internet as well. So I think we have some questions. Will annual EEO reporting still be required? To my knowledge, I think EEO reporting so far is still going to be required. If somebody has something different, let me know, but I think at least for EEO for right now. But the Trump administration has halted investigatory investigations and audits and lawsuits by OFCCP. Now, if OFCCP isn't around, I'm not sure. I couldn't tell you. EEO is going reporting still be required. I think we have a lot that is yet to be seen. So the answer to that question could change today, or it could change in 2 months. Who knows? I think the real important question is about some other things from our lovely practice group leader Chris. But we'll answer that later. But so I know we've pushed up with time. These are two very important topics that could be done in one webinar by itself without us sharing. But because of the importance of the two and the fast-paced movement of this administration, we wanted to try to put this together to kind of give you the information because it was very necessary. We'll definitely be doing this again to make sure you have this information and maybe allow for some more time, because it's going to change. I mean, Garrett and I can guarantee you that it's going to change, and you're going to need to hear more about this. So if you do have any questions right now, please send them in. Our contact information is up on the screen. If you can't get it in here on the webinar, send us emails directly or send an email to Chris, Katie, Alice, any of us in the employment group, and we'll be sure to kind of help you out and try to assist you. Give us a call as well. We thank you again. Could have been anywhere in the world. You decided to be here with us. Wish we had a little more time for you, but if you have a question I want to discuss something, please give us a call. Thank you again. Hope to see you next month.
Thank you.
Thanks for joining this webinar presented by Haynsworth Sinkler Boyd. To learn more about the firm and its services, visit hsblawfirm.com.